Baruch atah Adonai Eloheinu melech haolam asher kiddushanu b'mitzvotav v'tzivanu la'asuk b'divrei Torah. Varivna Adonai Eloheinu et divrei Toratcha b'finu v'yimcha beit Yisrael. V'niyeh anachnu v'tzeitzeinu v'tzeitzeimcha beit Yisrael kulanu yodea shemecha l'mdei Toratech l'shma. Baruch atah Adonai l'mei Torah l'mo Yisrael. Baruch atah Adonai Eloheinu melech haolam asher b'chabanu mikol ha'amim v'natan lanu et Torato. Baruch atah Adonai noten haTorah.
Amen. 7 times since you started. You should know by now.
Okay, next time you start the brocha. Thanks, but all right. So we're going to start off with Mishnah Brura. Okay, and today's the exciting thing about brochas after drinking alcohol and while drunk.
Yeah.
Part 2. All right, quickly. There are 3 types of drinkers in halacha. One who would still be able to speak well in front of a king, because Hashem is the king. One who would not be able to speak well in front of a king, and one who is absolutely drunk, like Lot, who got drunk after being saved from the destruction of Sodom and made some tragic mistakes. So with those 3 cases in mind, the general rule is don't even start, wait. As a rule, one is not allowed to pray nor bench if you had a lot of alcohol to drink. Rather, one must wait until the effect of the alcohol is subsided and only pray or then make the brochas. As far as Kriya Shema and Tefillah are concerned, if you did pray, if you were in case A, which means you were still sober enough to speak to a king, your Tefillah is valid. In case B, where you were unable to speak properly to a king, his Tefillah is an abomination and must pray again afterwards. Now, an abomination is a harsh term, so it's even more counterproductive than not praying at all. If one did bench, in case A and B, his bench and brochas is still valid, although it's better to wait until being sober. So there's a distinction here between doing Kriya Shema and benching, okay? Because firstly, I think benching has a certain time limit, that's one thing. In Kriya Shema, there's a cognizance of Hashem being obviously your ruler, your maker, your creator, and your sustainer. So there has to be a consciousness. So just to note in general about drinking is that it can't be emphasized enough how adamantly opposed to over-drinking the Torah is. In pretty much every case of drinking too much in the Torah, it is followed by a serious downfall in sin. As the Gemara says, Hashem loves one who does not drink a lot. I saw that pun with the word lot. I don't know if you saw that. They didn't. I don't know if the author intended it.
No, that's very clever. No, I didn't see it. Well done. No.
Okay. I don't know if it was interpretive. Eliyahu Hanavi told a certain Rav Yehuda, do not get drunk in order that you do not come to sin. That's in Brachos 29b, and this is from the Mishnah Brura 186, chapter 6, and the Shulchan Aruch 99 and 185. Okay, so all right. Basically, if an animal ate a garment, laundry, utensils, etc., this is considered an unusual act. It's not shame. Shame is when it benefits the animal and there's some form of physical gratification like nutritional sustenance or liquid to hydrate the animal. So no animal sits there and wants to eat a pair of trousers. So if the animal ate a garment, etc., only pays half the damage. So far that makes sense. Why? Because it's carrying damage, of which you pay half payment damages. And whereas it's said on the damaged party's premises, so that's fine. The Rabbi Tuffman says it's full payment for carrying on the damaged party's yard, but and then half payment damages in the public domain. But the rabbis in general all say that carrying half payment damages occur both in the damaged party's yard as well as the public domain, because there's no scriptural limitation in terms of in the field of another. That's number one. So what's very peculiar here is that it says on the damaged party's premises you're liable, but in the public domain, the animal's owner is not liable. So what should come to your attention is why in this case are you not responsible for carrying tum of the animal eating a garment in the public domain? That's the question that comes up. Okay. So the Gemara notes a difference of opinion regarding the meaning of the clause. Okay. To which case does the Mishnah's qualification, when are these things said, refer? Rav said it refers to all of them. So what do we mean about all of them? Okay, so you're going to have two opinions that come up here. Is that you're going to have an opinion of Rav and Shmuel, and as usual, they're on different sides here. Okay, so when Rav says all of them, there's two cases stated in the Mishnah. The first case is that the animal ate fruit and vegetables, and then after that in the Mishnah it says, and the animal ate a garment or utensil. So Rav basically maintains that when the Mishnah absolves the animal's owner from liability in the public domain, it refers to both the cases where the animal ate fruit and vegetables, which is understandable. Why is the animal's owner not liable if the animal eats fruit or vegetables? Because it's in the public domain. So that's a classic case of showing exemption in the public domain. And Rav also says, even in the case of a garment or utensils, which is in the case of Keren, basically, in this case, the animal's owner is exempt. Fine. So that was the first case. So what we want to do is clarify why it says this in the Mishnah. So the Mishnah holds as follows. Whenever one acts irregularly and someone else comes along and acts irregularly against him, the second party is not liable to pay. Okay. Do all of you understand that, or do you want me to repeat it?
Repeat that.
Just repeat that.
Just explain it.
Okay. So where this law of acting irregularly, it says whenever one acts irregularly and someone else comes and acts irregularly against him, the second party is not liable to pay. Okay.
Yeah.
So what this means is, in this case, Mark was minding his own business. All right. And I come up to Michael, and all of a sudden, I start shouting at him and then pushing and shoving him. And in return, he doesn't know who I am. He pushes back and then smashes me just because he's so shell-shocked. And I fall and slip and need a few stitches. Then I come to Michael and I try and have a whole legal case against him. They're going to obviously sympathize with Michael. Why? Because Michael acted irregularly and pushed me over a piece of furniture because I was the one that first acted irregularly towards him.
Okay.
It never happened in a vacuum. So the standard principle is, if you leave your garment or utensil lying in the public domain, you've acted irregularly. Why? Because everybody's entitled to travel through that public domain. And if you leave your possessions there, it's going to disappear. So therefore, if someone else comes along and acts irregularly against the person that left their garment there, so for example, it gets stolen or an animal damages there, he's not liable to pay. Why? Because you shouldn't have left your stuff there in the public domain. What did you think was going to happen?
I don't think it's considered stealing if it's in a public domain anyway.
Yeah, maybe stealing was a bad example because, but the point of it is, if you are negligent and you leave your object open, especially like you're on the beach and you go for a swim and you've got your purse or your handbag or your wallet open, you can't be surprised if somebody steals it because you've been negligent in leaving it there. Same thing with leaving articles in the public domain where somebody could trample. In other words, if you leave something in the road, it's very likely a car can come past and ride over it. Because it's not the onus of the car owner to... Kevin's asking something. Let me just put it louder. Kevin, what did you say? I can't hear you on the audio. You might come better on the audio. All right. I'm sorry. I just want everybody to hear you. Just hang on, Kev. I just want everybody to hear what you were saying. Just repeat what you were saying, Kev. I said stealing.
So if something in the public domain and it gets taken by someone, if they've given up hope, like Mitzvah, there's a more about Mitzvah. If they've given up hope, if you lose cash notes lying in the public domain, eventually you're not going to literally can't expect to find it the next day if you come back. So you give up hope. So if you give up hope, then it's not stealing, it's Mitzvah. Like in Damon, I'm sure you've heard
So, yeah, we are going to address Bava Kamma. We are going to just address a concept like that, which is an opinion given by Rav Chisda, which we're going to discuss just now. So that's a good point. So we are going to cover it. Well done. Honestly, that's what we're going to cover just now.
What did he say? Anyway, it doesn't matter.
Okay, just hang on, Kev. I want to just relay it to the guys. So there's a concept that if you give up something, where in other words, you give up hope of ever trying to find it, you've almost relinquished your rights to it.
Oh.
Does that make sense? But we're going to deal with that issue at a
Yeah,
separate forum,
yeah.
and it's going to come up in the later daf. Okay, so bottom line, guys, all you need to remember is that Shmuel has got this rule of Keren, that Keren you exempt, because the person that left their garment there should never have left it in the public domain, because it's likely to get trampled or ruined or stolen, etc. So therefore that person acted irregularly and was negligent. So if somebody obviously trampled on it or an animal ate it, that owner is not responsible. The person shouldn't have left their garment there. So Shmuel has a completely different opinion, is that regarding fruit and vegetables, that the owner is not liable, because that's a case of shame where there's an exemption in the public domain. With regards to the animal eating a garment, is that you are liable, because Shmuel sees it as a standard case of Keren, to which half damages are paid for the unusual nature of the animal, because it's not common that an animal would eat a garment anyway. I wonder what the case would be, and I'm sure as far as regul is concerned, you exempt if the animal tramples, because you exempt in the public domain for regul. So this is so unusual that the animal's eating it, that you do have to pay. But Rav said one who acts irregularly, if you act irregularly towards him, you exempt. Fine. So all we need to know is that the Amoraim of Eretz Yisrael had the same dispute about how to understand our Mishnah. Okay. Now I just want to go through one thing quickly. Just hang on a sec. Okay, we're on 28.3. Let me just see if I've got this correct. So, all right. So what I want you to remember is Reish Lakish. Reish Lakish has the same opinion of Rav. In other words, he refers to the case of non-liability for shame in the public domain when the animal ate fruit and vegetables, and also that if the animal ate the garment, that you exempt in the public domain because the person acted irregularly by leaving their garment. And Rav Yochanan holds like Shmuel, that basically said you are exempt for fruit and vegetable shame in the public domain, but in the case of a garment or utensil, the animal's owner is liable in the public domain for a standard case of caring. So Rav Reish Lakish actually brings an example. He said, if there are two cows in the public domain, and one was squatting and one was kicking, if the walker kicked the squatter, she is not liable. But if the squatter kicked the walker, she is liable. So I just want to explain this cryptic phrase. An animal squatting down in the public domain is considered abnormal because the animal has no right to just lackadaisic or like relax in the middle of a public walkway. That public thoroughfare is for almost what you call animal traffic to move from point A to B. If an animal's naturally walking and an animal that's squatting, that's acting irregularly, kicks the normal cow that's regularly walking and obeying the law, then that animal that acted irregularly is responsible. But when the first animal squats in the middle of the road or does something irregular and the second animal reacts badly, whether it's a case of carrying where the animal kicks as a reaction or normal regular walks past and damages the animal, you are not responsible. So all we see from here is Reish Lakish agrees with Rav, and he has that explanation in the Mishnah. Rav Yochanan agrees basically with Shmuel that it's a normal case of carrying because it's unusual for an animal to eat a garment or utensil, and therefore you are liable in the public domain. Now the Gemara asks a question: does Rav Yochanan, are we saying that he does not agree with Rav Reish Lakish in this particular example of the squatting cow and the kicking cow? So guys, there's two cases. There's a case that we learn in our Mishnah where the animal ate fruit and vegetables and then ate a garment or utensil. In this other Mishnah that Reish Lakish brings to agree with Rav, he's talking about one animal that acted irregularly and the second one that acted irregularly in turn. You're not liable because it was in reaction to the first animal that was acting irregularly. So what we want to know is now on that second brisa or Mishnah, does Rav Yochanan disagree with Reish Lakish, since Rav Yochanan holds like Shmuel that there is liability for this case of carrying, irrespective in that other case of our Mishnah of the damage to the garment or the utensil.
So, Damon, are you saying that, can I use an example? I'm not off track.
Yeah.
If an animal, for example, is unusually tearing a garment, and another animal from another owner joins in and does the same thing, tears the same garment, copying the other animal, are you saying, we've already discussed that the views are that they're both carrying, right? They're both carrying.
Okay.
Off track.
Little bit off track. This is my fault. I'm just going to present it in a clearer way.
Okay.
We've got our current Mishnah in 19b3, and what it says is if an animal ate fruit and vegetables in the public domain, you're not liable because it's a case of shame with this exemption. However, if the animal ate a garment in a damaged party's yard, you are liable.
Yeah.
But then it mentions a phrase, if it did in the public domain, you're not liable.
Right.
So we want to know why you're not liable, because every case of Keren Tam that we've learned up until now, there's liability for half payment damages in the public domain. And the reason why you're liable here is because animals don't generally eat laundry. Fine, that's your first case. So the reason is, according to Rav, that is that because the person should never have left their garment or utensil in the public domain, and as a result of that, that was an irregular act, almost what you call an act of negligence, and therefore an animal that trod on it wouldn't be liable. For the simple reason is you're not liable anyway for regular public domain. But in the case of where the animal found it very curious and the goat started munching on your boxer shorts, you can't blame the ox's owner, because what did you leave your boxer shorts in the middle of the public domain for?
Right.
Okay, so that's fairly straightforward. So what we're saying is that's according to Rav. Shmuel said that it's still unusual damage in the public domain, and he doesn't hold by this law of doing something irregular. He said if there's damage in the public domain, there's still half payment damages for having to charge your boxer shorts, and that is according to Shmuel. Now, Reish Lakish holds like Rav, that says you're not responsible because the one who acted irregularly has waived his right to claim from the person that has acted irregularly in return.
Right.
Fine. So Reish Lakish holds like Rav, and he brings a second case where there are two animals. There's an animal that squats and an animal that walks.
Okay.
And if the animal that squats suddenly just sits down and squats, and the other animal reacts badly, like by kicking this animal that acted irregularly by squatting in the public domain, the squatting animal that was injured, his owner can't sue the other owner for having his horse kick the other one's cow, because his cow acted irregularly by
Acted unusually,
public domain. Yeah.
Right.
So that's pretty straightforward. And even though Gavin is completely correct in saying it's not the law, and Gavin is right, is that in South Africa there would be pandemonium if you never made the other vehicle responsible for slowing down and keeping a correct, safe distance so that the car can stop in an emergency. One would at least, in a logical system, understand that if cars are traveling at 140 to 160 k's an hour on a highway, that if the car in front suddenly came to a grinding halt, most probably we wouldn't find the person that smacked him from behind behaving that recklessly based on the sudden stop of the car in front, especially if there was a truck behind him where he couldn't stop suddenly because he would end up being squished. Whether or not legally he'd have to pay in South Africa with secular law is a different matter. But logically, it never happened in a vacuum that he hit the other guy. So what we want to know now is, since Rav Yochanan holds like Shmuel, that considers that first case where the goat eating boxer shorts that were left in the public domain is liable because it's unusual damage, and you still pay half payment damages for carrying tam. We asked what Rav Yochanan, who was Reish Lakish's contemporary, and we basically say, well, how does he deal with that brisa or that example that Reish Lakish brings of one cow squatting and the other one acting irregularly in return and reacting badly, of which Reish Lakish exonerates the second cow because you cannot prosecute the cow that owner who acted irregularly as a result of the first one acting irregularly. We want to know what he deals with there. And what we say is Rav Yochanan actually doesn't disagree. It could be that, in fact, he does. It says, shall we say that Rav Yochanan does not hold the view of Reish Lakish, even in regard to the ruling about the two cows? And the Gemara replies, no, it's not necessarily so. In fact, it might be that Rav Yochanan does hold the ruling of Reish Lakish in regard to the two cows, for the case is not comparable to the case of the Mishnah. What is the difference? In the Mishnah's case of the garment or utensils, it is common for people to set down their coats and rest for a while. But it is not normal for an animal to squat in the middle of the public domain. So Shmuel and Rav Yochanan saying in our Mishnah 19b3, the fact of it is that many people, sometimes they rest and they take off their coats, etc. So it's not completely irregular. So they don't feel that the person has acted irregularly by maybe leaving their coat there. It's not like you're walking on a highway and you suddenly come to a stop. We're talking about a case maybe where there's regular stops, etc., etc. So let me give you an example, Gavin, an analogy. We're not on a highway, okay? And we're in a quiet road at which there are multiple robots. And I come to a stop because the robot is going from green to orange to red. And I come to a stop and you don't see me and you smash behind me. Now, that is quite common for a car to slow down because the speed limit is 60 and there's a robot indicating to slow down. Are you with me? If you smash me, then you're totally responsible because it's normal for cars to go under 60 k's an hour, kilometers an hour, and to have indicators to slow down at a robot. Whereas at a highway, there is no robot and cars travel at 140 k's an hour with no indication that there's a sudden stop.
Okay.
Am I making sense,
Yeah.
Gav?
Yeah.
No, I'm listening, 100%.
So that's according to Shmuel. So he's saying that, listen, in the case of the two cows, Rav Yochanan and Reish Lakish can be on the same page, but certainly not in this case where it's not irregular, according to Shmuel, of somebody to set down their coats and rest. Okay. So we're going to deal with the next section next time. We've got 4 minutes left. We can stop.